Good afternoon, everyone. House Taxation Committee will come to order. First item on the agenda is requests for bill introductions. Are there any requests? Chair recognizes Representative Coleman. You might make sure the microphone's on.
Thank you, Mr. Chair, for recognizing me for a bill introduction. I do have a bill introduction. It is RS 1111, and this bill would give it is tax related. It would give a property tax exemption for disabled veterans.
Thank you. Any questions, committee? Seeing none, any objection? Seeing none, the request is approved. Thank you, Representative.
Thank you, committee.
Are there any other requests for bill introductions? Chair recognizes Representative Gartner.
Thank you, Mr. Chairman. I just couldn't, my friend Representative Corbett had one yesterday and I wanted to follow in his footsteps. I do have a bill to introduce. It is 21 RS 1655. And this bill is it's a different bill. No, this bill is, I don't want to say compromise, but it takes some of the revenue enhancements and bills that we are hearing with some other tax reductions into one bill.
Committee, any questions for Representative Gartner? Do you know what the running count is between you and Representative Corbett now?
I think he's ahead, Mr. Chairman, by one.
Any further questions, committee? Seeing none, any objections? Seeing none, the request is approved. Thank you, Representative Gartner. Representative Corbett, do you have a bill? No. Okay. Any other requests for introductions, committee? Seeing none, we will move on to our first item of business for today and look to the reviser for an overview on the marketplace facilitator, or not the reviser, excuse me, research. Eddie.
Sure. Thank you, Mr. Chair. Let me share my screen really quickly. You should have received a memo from me that hopefully is up on the screen now in the room, and it kind of highlights what I would describe as kind of five clear differences between the two marketplace facilitators bills that this committee will have heard after today, and then also does kind of lump together one other category that might be loosely described as definitional differences. And so I'll just kind of walk through these these differences really quickly. The one caveat that I will give you is that, especially when we get more towards the definitional differences, those tend to be quite technical in nature. And try as I might, I probably am not able to comment on those as effectively as your proponents and opponents for today's bills will be able to. And so for that reason, I would kind of recommend that you consider holding your questions on those issues for those conferees. But getting into these bills, the two bills, of course, are House Bill 2173, which the committee has already heard, and House Bill 2395, which the committee will be hearing here momentarily. Both bills obviously would require marketplace facilitators to collect and remit Kansas retail sales and use tax and certain other taxes. Probably the biggest, most substantive, most obvious difference between the two is this question of a de minimis threshold. 2173, which we've already heard, contains what might be described as a de minimis threshold, in which the kind of requirements of the bill don't apply to marketplace facilitators unless they have either taxable sales of $100,000 into the state or facilitate taxable sales of $100,000 or more into the state in the previous calendar year. House Bill 2395, which you will hear today, does not have this sort of de minimis threshold, and so that is pretty much the most obvious difference between the two bills, I think. The next one is one that I included in the memo because it is a difference between the two bills as they exist now. But as a conferee, at least one, maybe multiple conferees indicated that maybe resolving this difference was actually the intent of the first bill, and that is that House Bill 2173, via the definition section, would appear to exclude certain hotels from coming under the requirements of the act. And as you might remember, at least one conferee on that bill who was a proponent for it indicated that that was unintentional in nature, and that they recommended a proposed amendment to resolve this exclusion. House Bill 2395 uses a different definition section for marketplace facilitators entirely, and so that kind of exclusion really doesn't come into play under 2395. The next kind of key difference between the two bills is the effective date for the prepaid wireless 911 fee collection requirements. Both bills do involve this fee and do require marketplace facilitators to collect and remit this fee. However, House Bill 2173 has an effective date for this requirement of July 1, 2022, and House Bill 2395 has an effective date of this requirement for July 1, 2021. The fourth kind of difference that I've highlighted here is one that exists in House Bill 2173. It does not exist in House Bill 2395, and that is a provision that specifically allows marketplace facilitators and the remote sellers to contractually agree to have the seller be the one who collects and remits all relevant taxes in the event that the seller has an annual gross nationwide sales of at least $1 billion, and that the seller is registered to collect and remit sales taxes under the Kansas Retailer Sales Tax Act. And so this is an instance in which the tax would still be required to be collected and remitted, but 2173 allows for this certain instance in which the marketplace facilitator can contract with the seller to place the onus for that collection and remittance on the seller and not on the marketplace facilitator. It isn't a tax avoidance issue, but it is an instance in which it's a change of who is responsible for collecting and remitting the sales tax. And the bill that you will hear today does not appear to contain this allowance. Another difference, and the last of the five kind of substantive differences that I mentioned, is the repeal of what are sometimes referred to as click-through nexus provisions. The bill that you've already heard, House Bill 2173, does repeal these provisions. Today's bill does not. A little bit of history and information regarding what these provisions are. They were enacted in 2013. They were one of the state's approaches, and Kansas isn't the only state to employ this approach, certainly, to try to get at as much of these sort of remote sales coming into Kansas as possible. Prior to the Wayfair decision, there was a Supreme Court opinion that indicated that in the instance of when businesses use affiliated persons to refer in-state customers, and those affiliated persons have an in-state presence, that is kind of creates a click-through, what is described as a click-through nexus to the remote seller. And so under that instance, it kind of bootstrapped that transaction into Kansas, and the seller was deemed to have a substantial enough nexus to Kansas to be required to collect and remit sales tax. The bill that you've already heard repeals those sections. Today's bill does not repeal those sections. It might be a good question for the conferees in terms of if they think those sections are actually still relevant, would today's bill come into effect? And then the other thing that I've highlighted here is kind of these other differences, and these are largely definitional in nature. The bills use different definitions of marketplace facilitators. It appears to me that those differences still largely arrive at the same point, and getting into where they might differ would be a very technical question that the conferees might be able to respond to. They also differ in their inclusion or exclusion of certain other definitions, whether or not they explicitly incorporate by reference the other statutory provisions of the Retailer Sales Tax Act. Today's bill does, whereas House Bill 2173 that you've already heard does not explicitly refer to that. And also the other thing that's probably worth mentioning here is that there's a difference in terms of the exact kind of statutory technical legislative approach they use to get at the requirement that marketplace facilitators not only collect and remit the retailer sales tax, but also the prepaid wireless 911 fees and transient guest taxes. Both bills contain both of those additional taxes, but the legislative language for getting to them is a little different, and I imagine that is just a difference based on where it originated, but it doesn't necessarily appear to be a substantive difference. But that's kind of all of the differences that I would highlight, and I would happily stand for questions.
For that explanation, Eddie, committee, any questions? Representative Sanders.
Thank you, Mr. Chairman. Edward, I'd like a definition of de minimis.
Sure. For purposes of this legislation, the definition of de minimis is annual taxable sales of $100,000 or more into the state. Obviously, that isn't necessarily the only possible definition of de minimis, but that is the one that is involved in House Bill 2173, and there is not a threshold for de minimis in House Bill 2395.
Thank you.
Mm-hmm.
Eddie, if I could follow up on that, I just wanted to clarify, I think I did this during the hearing as well, but that $100,000 threshold is only applied to, it's not per seller, it is applied to the marketplace facilitator as defined in both bills, I believe. Is that correct?
That is how it is defined for purposes of 2173. It is if that marketplace facilitator either facilitates a total of $100,000 in sales, or if sometimes companies are both sellers and marketplace facilitators, or if they have sales of $100,000 into the state. Yes.
Committee, any further questions? Eddie, I know you said might direct some of these more towards the conferees on the bill, but I was just curious on, if I go through the differences that you have provided here, looking at number 1 on the de minimis threshold, and possibly also number 4 on the permission of the seller and the contract with the seller and the marketplace facilitator. Do we have any data that says about approximately how many, if any, companies would qualify for either one of those provisions?
So in essence, how many people would be excluded from the requirements by virtue of not meeting the de minimis thresholds, and how many situations might allow for? I am not aware of any such data. The Department of Revenue, it's possible, might have some. Beyond that, we could try to dig into some industry sources, but I'd be a little hesitant to expect anything.
Right. Okay.
De minimis thresholds, tend to exclude instances in which people would fall through the cracks. So,
right. Okay. Thank you. Are there any other further questions or research? Seeing none online and none in the room. Thank you, Eddie, for that presentation.
Mm-hmm.
This time we will open up the hearing on House Bill 2395, and I would look to the reviser first for an overview.
Thank you, Mr. Chairman. Yeah, just going on what Eddie said, I think he did a pretty good job summarizing both bills. So I'll go through mine quickly on 2395. Of course, it's requires the collection or remittance of sales, compensated use tax, transient guest tax, and prepaid wireless 911 fees by marketplace facilitators. Well, there's a lot of kind of administrative process in the bill. I kind of go through the major sections. of the bill that really are the kind of the meat of the bill. Section 2 would define, among other things, the main components are marketplace facilitator and marketplace seller. Those are kind of the issues that are at heart in this bill of what those are and what constitute them. Section 3 of the bill would require, as Eddie said, marketplace facilitators to collect and remit sales tax starting July 1, 2021 for sales made through the marketplace. Section 4, a marketplace facilitator would be required to provide KDOR information that is reasonably necessary to enforce the provisions of this act. The marketplace facilitator would be relieved of liability if the information it provided was incorrectly provided by the seller. Marketplace sellers would not be obligated to collect and remit sales tax if the facilitator was obligated to collect and remit. So both don't have to collect and remit, obviously. Purchasers would not be able to bring a class action against a facilitator for claims related to the overpayment of taxes collected by the facilitator. However, they could go through the refund process. Section 7 requires marketplace facilitators to also collect and remit transient guest taxes and 9/11 fees. And then lastly, Section 11 would amend the Nexus statutes that currently exist in statute. It removes references to referrals for Nexus for retailers doing business in the state. It provides that Nexus for retailers would be that sell tangible personal property or services for or on behalf of the retailer. And with that, I'd be happy to stand for any questions.
Thank you, Adam. Committee, any questions? Representative Corbett.
Thank you. On the bill we're going to hear today, 2395, there is no threshold for 100,000. There's no dollar threshold like in the previous bill. There's no maximum they got to reach before they have to start remitting. I'm misunderstanding that.
Representative, that is correct. $1 sales into the state or facilitated would trigger the new provisions under this bill.
Representative Highland.
Thank you, Mr. Chairman. Page 4, Section D, line 26. Would you explain that paragraph to me, please?
Representative, essentially, it's my understanding, and I probably may defer some to the Department of Revenue if they'll be testifying. I know they were instrumental in coming up with this language. It prevents individuals from being able to file a class action lawsuit against a marketplace facilitator. If the marketplace facilitator imposes an overpayment of sales or use tax, and these are collected by the marketplace facilitator. So it's kind of a preemption against a class action against the facilitator.
Mr. Chairman.
Now that as I take a look at that, is there, and perhaps we can have Department of Revenue address that a little bit further, but I guess I was just curious if that is an over collection or an overpayment of the tax. We might have to dive into that a little bit further, but any other questions, committee or the reviser? If not, I just have one, Adam. On Eddie's presentation, he talked about the click-through nexus. The previous House bill that we heard repealed that. This bill does not. Is a click-through nexus not, if this bill would pass, would that not be redundant now if we no longer have a requirement for nexus since we have a marketplace bill? Or would that just apply, would that still apply to somebody, say, under that $100,000 threshold? Well, actually not in this bill, but would that not be a redundant policy at that point?
Mr. Chairman, I do agree with your line of thinking. I'd probably defer to the Department of Revenue to address that since they are truly the collectors and administrators of this tax, whether or not they believe they need those provisions or not any longer.
Thank you. Committee, any last questions? Seeing none in the room and none online, thank you, Adam, for your overview. And we will now turn to Department of Revenue for an overview of the fiscal note.
Chairman and members of the committee, Kathleen Smith with the Kansas Department of Revenue. We are estimating that House Bill 2395 would increase state revenues by approximately $51.5 million in fiscal year 2022. Of that total, the state general fund would be estimated to increase by $43.1 million in fiscal year 22, and the state highway fund would estimated to increase by $8.4 million in fiscal year 2022. As we grow out to fiscal year 23, 24, 25, and 26, we have grown it around 5%. So in fiscal year 2023, the total receipts would be around $59 million. In fiscal year 2024, $62 million, and so on. To formulate the estimate, what we did is we reviewed data that was provided, or by a study that was provided by the GAO, the U.S. Governmental Accountability Office. We started with that study. We also reviewed industry data for this type of industry. We also looked at other states' information that they had provided, and therefore then we were able to formulate our estimate that we have provided to you. With that, I would stand for any questions.
Representative Highland.
Thank you, Mr. Chairman. That's good. Thank you very much. But we had an earlier question. What would be the difference between this one and the other bill where they have the $100,000 threshold? Have that?
Okay, so with the 100,000 de minimis that we have on some other legislation, the 100,000 de minimis applies to both the remote sellers and to the marketplace facilitators. What we have found is that probably the de minimis is really going to affect the remote sellers, and so it would average around 9 million. That difference would be around 9 million.
9 million reduction in these figures?
Correct.
Thank you. I appreciate that. Thank you.
Committee, any further questions for Department of Revenue? Kathleen, did you have any comments on the click-through nexus and whether or not that would be redundant language, or do you want to let Mr. Hale address that?
I am going to let Mr. Hale address that if that would be okay with you.
Okay, thank you. Any further questions? Seeing none, Kathleen, thank you. We appreciate that. At this time, we will open up the proponent testimony and welcome first to committee Michael Hale, Deputy General Counsel with Kansas Department of Revenue.
Mr. Chairman, members of the committee, thank you. Michael Hale with the Department of Revenue. Appreciate the opportunity to speak with you all today. 2395 is an outgrowth from the Governor's Tax Council, Council on Tax Reform that addresses the collection of compensating taxes on sales made by marketplace facilitators. As you're
Mr.
aware,
Hale?
Yes.
Would you mind getting maybe a little closer to the microphone? It's really muffled and a little bit tough to understand on our end, if that's possible.
All right, I will do my best. Could you hear anything at all that I said? Or do you would like me to start?
We can hear you just fine. We just can't understand it.
Well, that may be more, not my voice necessarily. Well, by way of background, 2395 actually started last session in House Bill 2657. And in April of last year, the Chamber and industry and the department met and we reviewed and discussed, exchanged emails, and we made some modifications to that bill. but because of the pandemic, it never got across the finish line. So rather than reintroduce the exact same bill from last session, just kind of picked up from where we left off last April. So that avoided all of the need to re-meet and rediscuss and re-amend, etc. Largely the language you have before you was generally agreed to by both the chamber and the industry and the department. So for example, was pointed out earlier, the class action lawsuit exists in both the chamber's bills and in this bill today. So there's some similarity, but there are some key differences, as Mr. Pinner pointed out. I will go straight to the click-through, since that came up. If you turn to the bill on page 8, beginning on line 18, this is the click-through part. And if you'll notice, stricken from the statute now is refers potential customers, whether by link, that's the click, or internet website, to the retailer. So the click-through is actually struck and would no longer apply in this bill. The difference between 2173 and when you pick up Senate Bill 50, or if you pick it up, it reads the same. That entire section is struck. It goes beyond striking just the click-through. So it strikes out telemarketing, in-person party sales like Avon, Pampered Chef, Tupperware, those kinds of things. Those have always been subject to the Kansas sales tax for years and years. This bill leaves those as is, only strikes out the click-through portion. 2173 and 50 strike it all. And I'm not sure that that's something that the legislature really would intend, to not have those sales collected by Avon as opposed to each and every individual seller that goes from house to house. As noted, there are some differences between the Chamber's bills 2173 and Senate Bill 50 and this bill. The largest difference, obviously, is the de minimis. This bill has 0 de minimis. 50 and 2173 have the $100,000 threshold. But there's more. For example, last year, the bill contained an obligation that if you were required to collect sales tax, any other taxes would also be due. This would include the E911, transient guest, but would also include tobacco products, alcohol, etc. This was a sticking point with industry and the chamber and the department. And so the department agreed to limit it for this year to just E911 fees and transient guest fees. But having said that, the department believes that there are a lot of commodities now being sold on platforms into Kansas without the appropriate Kansas tax. Tobacco products, alcohol, for example. This will hurt Kansas businesses in your communities. So don't be surprised in another year or two when those businesses come to you and say, hey, we need to have our taxes collected as well. The other difference in this bill and the Chamber's 2 bills are that this bill only addresses sales made by the facilitator. The Chamber's 2 bills go beyond the facilitator and also extends to the remote sellers. And then, as we've already discussed, the de minimis question. I know that the de minimis was hotly discussed last session, and I've heard debate this year as well. If you elect to enact one of the Chamber's bills, you're treating your in-state businesses, people who live in your community, differently than these out-of-state businesses. And $100,000 might not seem like a lot, and to these megalithic platforms, they're not. just walking around money. But to the small businesses in your community, $100,000 is really large. So that is a key difference in these two bills. This bill treats in-state and out-of-state sellers the same. Then there are some other differences in the bills, and I think Mr. Penner did a pretty nice job in distinguishing between them. I won't go into a lot of detail because it's kind of boring, but there are certain terms used in this business model, like affiliated person, cumulative gross receipt, transaction, and so forth. Those terms really need to be defined, and 2395 defines those terms. The other two bills do not. By defining these terms, having everybody clearly understand what is and is not an affiliated person, it just avoids uncertainty and unclarity, and avoids the risk of litigation. 2395 is a broader, inclusive definition of facilitator. In essence, all companies that bring buyers and sellers together are included as facilitator under 2395. And that generally rings true in most of the states that have facilitator bill. 2395, and this goes to the hotel question, includes the large out-of-state multinational hotel booking companies, as well as companies that facilitate the lodgings in homes. This avoids an unequal application of Kansas law and will keep us out of litigation because it will apply to all hotel booking type companies, as well as companies that specialize in the leasing of homes or cabins, etc. This also keeps in concert with the concept that has been rooted deep in Kansas sales tax law, which is that the sales tax is a gross receipts tax. If the booking fees are eliminated, then you've actually got a net receipts tax and not a gross receipts tax. Most states adopt the gross receipts approach to their taxation. 2395 maintains that for hotel bookings. 2395 requires the collection remittance on the first sale in the current or previous year. This is just like in-state businesses. When an in-state business first opens the doors to their business, they have to begin collecting and remitting. This bill does exactly the same thing for facilitators. Senate Bill 50 and 2173 only require the collection and remittance the next year after the threshold is met. So by example, if the threshold is met in February of 2021, that facilitator will not have to start collecting and remitting until 2022. That's a pretty decent sized grace period that in-state businesses don't get. This elevates the large out-of-state companies to a higher level, if you will, than your in-state businesses that are in your local communities. So 2395 treats the in-state and the out-of-state equally on this part. 2395 also applies the terms and the definitions and the administrative processes of the existing Sales Tax Act to the marketplace facilitators. I don't see that in Senate Bill 50 and 2173. This could lead to confusion, compliance questions, administrative problems, and conceivably could lead to litigation. So 2395 incorporates all the provisions of the Retailer Sales Tax Act into this bill. 2395 does not allow facilitators to contract away their obligation to collect and remit. And I think Mr. Penner touched on that with regard to the $1 billion sales question. This arose out of the large telecoms concerned about one entity collecting 911 fees and another entity collecting sales tax. They didn't think it was necessary to have two separate entities on more or less the same transaction collecting. 2395 does away with that. Excuse me. Because it applies to 911 fees and does not attempt to tax advertising, it addresses the telecom's concerns. 50 and 2173 keep this language in there, but they also have the 911 fees included. So this language in 2173 and Senate Bill 50 is actually just surplusage and could be struck. This is certainly language that we had last year, and the telecoms were okay with it. And really, the chamber did not express any concern last year either. 2395 keeps the question of doing business in the state, that definition, as it already exists in 793702H. But Senate Bill 50 and 2173 use a different definition of doing business in this state, and it's inconsistent with the existing doing business in this state. So we would prefer that 2395, which retains the existing language of doing business in this state, be used. And as I said, we've already addressed the click-through nexus question. Really last year, this language was proffered to industry and the chamber that you have here on page 8 of the bill, and they didn't seem to have any opposition to it. The department would urge that the committee favorably consider 2395. It stays true to the tenets of the Sales Tax Act that's been in place for years and years and years. It provides a clean, concise use of language and definitions to eliminate any uncertainties or questions. That avoids litigation, which is always a good thing. It does not use unnecessary provisions or sections that simply don't apply. For example, Senate Bill 50 and 2173 strike out to or eliminate from the definition of facilitators like derivative clearinghouses. Not even sure why that's in those bills, because we don't impose a sales tax on derivative clearinghouses. 2395 does not do that. It enhances the collection of legally due taxes, and most importantly, it treats both in-state and out-of-state businesses equally. I'd be happy to answer any questions that you all may have.
Thank you, committee. We have two proponents verbal, so I think we'll go ahead and take questions at this time for Mr. Hale. Are there any questions, committee? Representative Baker.
Thank you, Mr. Chairman. Thank you, Mr. Hale, for that presentation. So one question that I was asked the other day, and I wanted to make sure it was correct, are the city and county taxes that we assess locally, are those also collected when we have internet sales? Do they use the destination sales tax as the rate of sales tax to be collected?
Yes, they would.
And in some of those areas, we have special taxing districts within a zip code. Would that be included, or we?
Yes, for sales tax purposes, yes, all those special little community taxes would be included in this bill.
Okay, thank you very much. Thank you, Mr.
Any further questions, committee? Representative Gartner.
Thank you, Mr. Chairman. Thank you, Michael, for going over the bill and the differences. I guess I'm a little confused. We worked on this bill for, it seemed like months last year. I know we weren't here that long, but we ended up, I believe, on Zoom in May. And there were a lot of differences in those bills, but then we came together, I thought, the department and the chamber and a number of participants. Is that correct?
Yes, it is.
So I guess my question is, and maybe it's not for you, why are we so far apart now starting this year? And I would think we would be much closer together in the language in both bills.
Well, I think, of course, the largest difference is the de minimis, and that's been debated last year, almost from day one, and it's still being debated today. And I've heard it in both the Senate and the House. Some people believe that we need 100,000, others believe 0. And so it's a matter of fair debate, and that still exists. The other differences, for example, the click-through, I don't think is a difference. I think I pointed out, hopefully, on page 8, that the click-through is out of the existing statute. So that's really no longer a difference. The department agreed to accept that last April. The hotel thing, that is a difference. We don't think the chamber has a significant issue with that. This was coming more from the West Coast, large booking companies. And we believe that it should be subject to the sales tax and the transient guest tax based on gross receipts, which is the way our in-state hotels have to do it. And so do the lodging companies that have homes and cabins and apartments that they rent. So why shouldn't these large booking companies follow the same path? 2395 stays, we stick to our guns on that. That's the same as it was last year. And so there is a difference in the two bills. There were a lot more differences last year than these 4 or 5. Trust me, there was probably 10 or 12. So we did eliminate a lot of those differences.
Yes, Mr. Chairman, I know you did, but just when I read through your material, you say that, well, back in, we thought we were in agreement, but, 5 or 6 places I saw that. So, but you've answered my question. Thank you.
Mr. Hale, I have a question for you regarding Section 7 in 2395, specifically comparing it to 2173. In Section 7 of this bill, it specifically talks about the Kansas Retailer Sales Tax Act or the Kansas Compensating Tax Act or the transient guest taxes. Now, in the other bill, 2173, it just simply references the retailer's sales tax imposed in KSA 79-3603, the compensating use tax 79-3703, and the transient guest tax. Is there any difference in those definitions? But since we're not addressing, like in 2173, we don't say the Kansas retailer's sales tax. We just reference the statute. Is there any functional difference in those definitions?
No.
That's an easy answer to a long question. Committee, are there any other questions? Seeing none in the room and none online, Mr. Hale, thank you very much for your testimony.
Thank you.
Next proponent, I'd like to welcome to committee Trey Cocking with the Kansas League of Kansas Municipalities.
I think that's what's on our business cards. Good afternoon, Chairman. Good afternoon, committee members. We're supportive of this bill. We're supportive of Senate Bill 50. We just want to get something over the line. Is this better for Kansas taxpayers? Probably, because they're on the same ground already as out-of-state sellers. So I don't know. I mean, if I'm looking at this, I don't know why we try to make things easier for out-of-state people than we do for in-state people. I guess that's my question for this committee. If I'm that hardware store on Main Street, I probably want as equal a field as possible. But at the end of the day, I don't want perfect to stand in the way of great. I want to see a bill get over the finish line this year because it is vitally important to our member cities. Last thing I'll report is, remember, 30% of Amazon sales are going untaxed right now, and let's get that money in and then figure out what else is out there. I'll stand for any questions.
Thank you. Committee, any questions for Mr. Kotke? I guess I just have one. Without speed reading your testimony here, where do you stand on the $100,000 de minimis?
Yeah, we think a lower de minimis is probably better, but we want something that's going to stand up in court. You know, is $50,000 going to stand up in court? I would say probably yes. Is zero? Probably not. If the Department of Revenue goes out after somebody selling $20 worth of products in Kansas a year, that's not going to sit well with the Supreme Court, and that's going to be who they fine. You know, so yeah, is there a compromise there? Probably something you guys could find. But we just, at the end of the day, we want something that gets across the finish line.
Representative Baker.
Thank you, Mr. Chairman. Thank you for your testimony there. So maybe another compromise would be just if we put the $100,000 threshold for our local merchants too?
You know, our concern always with that is there's a big loss in sales tax revenue in that case, but you know, is there a, you know, $10,000 compromise there? I don't know what that number would be without running the report from the Department of Revenue.
There will be an amendment with a number on it to include all the locals to match all the out-of-state people. So we'll look forward to that. Thank you.
Thank you for that warning, Representative Baker. Committee, any further questions for this conferee? Seeing none, thank you for your testimony. Committee, I'd also address your attention to written-only proponent testimony from Emily Fetch with the Kansas Action for Children and Mike Koss, attorney for the City of Overland Park. Is there anyone else wishing to testify as a proponent on House Bill 2395? Seeing none, we will turn to our opponent testimony and welcome to committee Mr. Eric Stafford with the Kansas Chamber.
Good afternoon, Mr. Chairman and committee members. I'm Eric Stafford with the Kansas Chamber, here to speak in opposition to House Bill 2395. Really two main points. I think included in our testimony is a summary of the 50 states' transaction dollar amount or transaction number threshold that they have in place to have their laws kick in. And you'll see, you know, the trigger. So South Dakota, being the state that was tested, it was $100,000 in sales or 200 transactions. So if you had 200 transactions but $30,000 worth of sales, you're obligated to comply with their law. So as this has become a growing trend nationally, and we're now one of 3 states to address this, overall we do support the policy, but feel that our version is a better version, just speaking bluntly. The South Dakota approach, what we heard from our members, because we do have the larger multi-state retailers, we do have some small Kansas-specific retailers that have an online presence. And those retailers gave us feedback, the smaller ones gave feedback that when we had a bill drafted 2 years ago on this that said, you know, if we could just focus on the dollar amount, because we're high volume, low dollar sellers, and we're getting caught in these webs of enforcement in other states over, you know, $20,000, $30,000, $40,000 worth of sales. So we took that feedback. Our other retail members didn't have any objection to that, and the bills that we've been introducing have only focused on the $100,000 transaction limit. You see that's a growing trend. Some states that have started with the 200 transaction limit have eliminated those and only have a dollar amount. There are some states that are or, but there are some states that are and. So if you have 235 transactions but $80,000 worth of sales, and there's an and, they don't qualify. I would, focusing back on the $100,000 threshold, as you go through our testimony, you'll see not one state has below $100,000 in their threshold. There are some states that have $250,000. There are some states that have $500,000. There are some states, and I think it was Tennessee was the only one that I referenced, yeah, formerly $500,000. There are some states that have been $250,000, $300,000, $400,000, $500,000, and then over a 2 or 3 year period, they're phasing that back down, but still ultimately nobody's going to end below $100,000, and I would encourage Kansas to not be the first state to try this. You guys heard testimony last year when you had the Secretary of Revenue talk and then you had the Attorney General talk, and the Attorney General told the committee the further you deviate from Kansas, the more inviting you are, or the further you deviate from South Dakota, the more inviting you are to litigation. He will defend it, but it's a harder challenge. So our preference would be to keep that $100,000 threshold in place, again, which our versions have. Second point is page 5, section 7B of the bill. The bill defines taxes as the chairman asked his question about sales tax, transient guest tax, compensating use tax definitions. But there's a vague section in section 7B on page 5 that talks about any other taxes and fees. And this was a hang up for us last year. And we just have strong concern over what that could be. We had some of our retailers look into this and they found that we could have up to 40 fees or taxes that could comply under this if Department of Revenue, by rule, which they've implemented this legislation by rule. Our Attorney General has issued an opinion stating that he doesn't believe they have the authority to do so, but it hasn't been challenged. The concern there is, well, what is other taxes and fees? If I buy tires through TireRack.com but have them installed here, who's responsible for the tire recycling fee that's obligated to be collected? Not being defined what other taxes and fees are. Our preference is to avoid that type of vague language and not have that included in the bill. So last year we were asked to work off of the Department of Revenue's language. We had identical bills to Senate Bill 50 and House Bill 2173 that we introduced this year. We had a bill last year. I can't remember the bill number off the top of my head. But that was our preferred approach last year. We were asked to work off the Department of Revenue bill. Our preference would be to work off of our bill. We're pushing for that this year. We just got Senate Bill 50 passed through the Senate last week. It was referred, I think, this morning or today to this committee. But that is model language adopted by NCSL that's supported by the telecom retail industries and ultimately has large support and has been worked through on a national level to try and get uniform language to address this issue on a state-by-state basis. So that really summarizes our testimony today. But we would just encourage you as you consider the marketplace facilitator approach and legislation that you do adopt the de minimis threshold as suggested by the U.S. Supreme Court in the Wayfair case. So happy to answer any questions you might have.
Thank you, Mr. Stafford. Committee questions? Representative Corbett.
Thank you for coming. One of the questions or what kind of popped up to me today was the League of Kansas Municipalities just testified. They were very concerned about businesses collecting more taxes. A couple of 3 weeks ago, when we were all here talking about when they locked the doors and people couldn't get into their businesses, they were very excited about maybe helping them out and reducing some taxes. It seems like the state needs a little more emphasis on stimulation for small business than keep trying to just tax them completely out of the state. I'm not sure this bill does much for brick and mortar stores.
Yeah, I think that the purpose of the threshold is to have, as the marketplaces and technology has shifted, you have individual sellers through Etsy or whatever website, eBay, whatever it might be, that might have $35 worth of sales in the state. And that is something that the Supreme Court specifically mentioned. You have to have a de minimis threshold in there to establish a reasonable presence within the state. Having one sale of $72 in the state isn't going to make that, I think the opinion from the U.S. Supreme Court, I don't think that meets their definition of having that presence, physical presence within the state. If you're selling $300,000 and you're based in Pennsylvania, that's probably, and you're selling it here, that's probably a physical presence in the Wayfair opinion. So the purpose of that de minimis threshold is to protect small businesses. Now, I think that the fairness argument that's being made on the other side is, well, there should be a $100,000 exemption for businesses located within the state. Okay, well, businesses located within our state have a $100,000 exemption to operate at minimum in all other 49 territories that have this same law in place. So they have help in other states too. This is just addressing online only purchases. This is not, it's not an attempt to address the brick and mortar people here when you go in and buy a product in person because you're paying sales tax on that. It's trying to establish in some fashion a level playing field. There are obstacles to that, and I think the Supreme Court acknowledged those, which is why they came out with their so-called checklist of what the Tax Foundation calls their checklist of items to follow in order to be in compliance with the law.
Representative Gartner.
Thank you, Mr. Chairman. Eric, you were talking about the threshold, and correct me if I'm wrong, I thought the Department of Revenue said in 2173 and maybe in Senate Bill 50, once you reach that threshold, it's not until the next year that you start remitting. Is that what I heard earlier? I thought Mr. Hale pointed that out, but I don't have the bill in front of me, so I know the chairman does, but it does say the following. Oh, okay. I know Mr. Hale said, I think it was the following year. And I guess my question is, if that's true, why wouldn't you want to start collecting as soon as they reach that threshold or surpass that threshold?
So it's saying a marketplace facilitator shall only be required to collect and remit such taxes if the following criteria are satisfied in the previous calendar year. And that's where you have the $100,000 exemption. I think that's just how they're written. I think it's intended to not give a pass for anybody who has it. It's just saying if in a past calendar year you have had $100,000 in sales, you're obligated to remit sales tax. It's not saying you don't have to send it till the following year. It's just saying you're obligated to follow the law. So I'm not an attorney. We can have some attorneys look at it and get some clarification on that and provide some cleanup language in 2173 or 50. I don't think that's our intention at all. I wouldn't read it that way. I would also not read 2395 as, or our bill, I'm sorry, 2173 is entirely striking the whole nexus statutes. I mean, when you look at that bill that we introduced, page 7, actually the statute starts on page 5 in section 5, 793702. It's not striking the entire statute, it's striking B, C, and D, and J, which are the statutes there on the click-through nexus. So I don't think we're striking the entire statute, we're striking 3 specific sections. So I think that's a misrepresentation of what's taking place there.
Okay, that might follow up or have an attorney look at that, but just to make sure. But just to follow up, Mr. Chairman, with the language on that you are not comfortable with on striking, I think the language dealing with collecting additional fees, you gave the example on buying the tires and who pays. Here's, I guess, a question that I have. For example, right now, there is a government mandate that states have to start dealing with suicide hotlines, if I remember correctly. And it's a nationwide 988, if I remember correctly, the number. And that's coming. That's coming to Kansas. And we're going to have to collect those fees on every wireless, wireline phone going forward at some point. So I guess my question is if that language isn't in there, if it is, we could just go ahead and start collecting those fees. But if we eliminate that language, we're going to have to go back into the statute and specifically talk about or be specific on collection, just like 911.
Sounds like 911's pretty specific because it's referenced in the bill, though, right?
But it's two different functions, 911, 988.
But then it doesn't matter what the function is. It's still going back in and amending this. I think you went back in and amended the statute for the 911 fee and the tax on that. So go back. Our suggestion would be to go back in and amend the statute for the 988 fee, just like you did the 911 piece. So I mean, I think leaving just other taxes and fees. I mean, we could always dream the unknown, right? And pending deals, but you know, and if that's coming, then and that needs to go in this bill because of timing, or our bill. I mean, I don't think, for clarification purposes, we'd have objection to that. But in our view, it should be specific as to what's obligated to be collected. Now, I would say the 988 fee, again, that's a timing issue. And just remind this committee, when we heard testimony on 2173, we didn't have uniform agreement among our membership on the effective date of the 911 piece, which we left it up to the committee. You guys pick what's best. The Senate ultimately amended Senate Bill 50. So the House version is July of 22. The Senate version was January of 22. The Senate committee amended it to April 1 of 22. So they split the baby, and that's what they went with from the Senate side. So our preference would be to be specific rather than just leaving it open-ended. Mm-hmm.
Representative Baker.
Thank you, Mr. Chairman. So the out-of-state retailer will go ahead and collect the sales tax, is that correct? And then when he finally gets to the $100,000 threshold, then he'll start remitting that?
The facilitator, yeah.
It's a pretty good bonus, isn't it?
Sorry?
That'll be a pretty good bonus for them. They'll get to collect all that sales tax, and if they don't, they make it to just right under the threshold, they'll get to keep that. Otherwise, they'd have to put it on every order so they don't have to claw back on it.
Yeah, I mean, that's the downside to having a threshold, but I conversely look for the small business that's not selling within the state of Kansas, that's selling outside of the state of Kansas, that are our members that are having to comply with every single state. And I know there's been some testimony in the past, well, because we're part of Streamline, there's no cost associated with that. There's software you can follow, but I promise you, when we talk to our retailers, especially our smaller retailers, just to open up and sell into a state, you're talking $2,500 off the bat per state. So that's the software to add that state. And then you got your compliance costs, and then the time and money it takes to send in there. So I look at it from the opposite perspective of our Kansas small businesses that do have an online presence, that are trying to grow their base and sell into these other states. If all those other states didn't have a $100,000 threshold, they're going to be getting stuck with all those compliance costs. So, you know, that's why we started our bill a couple of years ago by eliminating that transaction threshold, is to try to send a message, and thankfully other states got it too, of eliminating that transaction threshold to help protect the high volume, low dollar sellers from having to automatically step into compliance costs just because they have an online presence and are selling in other states. So we're looking at it from a probably opposite perspective from what you are.
Exactly. You have a different group that you represent than what I represent. That's the problem. I represent the small Main Street retailers that don't ship.
Well, and that's why I think that's what I'm trying to make the point, is we have some of those as members as well who do have a Main Street store, but they also have an online presence. And so, you know, we're not just only representing, you know, Best Buy and Home Depot and, you know, the big box retailers. When we testify on this, we do have feedback from Main Street, Kansas businesses who have an online store.
So you mentioned those large retailers. Do they collect the sales tax here in Kansas?
Yeah.
Thank you.
Representative Mason.
Thank you, Mr. Chairman. Eric, are you aware of any marketplace facilitators out there that would not meet that $100,000 threshold shipping into Kansas? And most of them are, like Wayfair, Etsy, eBay, Amazon. They're pretty sizable companies. Are there smaller companies out there doing that same thing?
As a facilitator, I'm sure there are. I couldn't name what they are, but you're also dealing with an online store that, I know it was probably 3 or 4 years ago, I bought a pair of golf shoes online that I found, and it was some guy's individual pro shop from a golf course out of Washington State, so I didn't pay sales tax on the golf shoes.
But he wasn't really a marketplace facilitator.
No.
Yeah, I understand that. So I mean, the $100,000 threshold, I think it's important to have it in there because of the Wayfair decision with the Supreme Court. But in the case of marketplace facilitators, it may be a moot point. Do you agree or not?
Say that question again. Sorry, I missed the last few words, and I just want to make sure I understand it.
Well, it's two parts, really. More of a comment, because I think the $100,000 or a de minimis threshold, not whether 100,000 or whatever. I think the de minimis is important because it keeps us in compliance with the Wayfair decision. Correct.
Correct.
The other point is that it may be a moot point because most of your marketplace facilitators are probably going to surpass that threshold anyway, but it gives us a twofold protection, plus we collect our sales tax. Am I correct on those assessments?
Yeah, and I think the department has acknowledged to this committee and the Senate Tax Committee in the past that as we've debated this issue over the last few years, I don't know, 8 out of the 10 or 9 out of the 10 larger online retailers or marketplace facilitators had agreements worked out with the Department of Revenue already. So that's why, in their view, because maybe I'm thinking back, maybe it might have been 2017, 2018-ish, there was a bill that was about to run on the House floor, and there's some question as to what the fiscal note should be, and whether it was too high or too low, and folks arguing, oh, it's too low, probably more than that. But the department was saying through their testimony at the time, the larger folks, they already had issues or agreements with the Wayfarers, those types of folks. So, yeah.
Representative Blex.
Thank you, and thank you for coming. Kind of explain to me the marketplace facilitator. I mean, we're talking Amazon, Wayfair. Let's assume there's and I'll use an area that I'm maybe a little bit upset about, but a gun shop in Missouri has over $100,000 in sales. Would they be considered a marketplace facilitator?
It'd be a seller.
And would they be, but they would be subject to that tax? Am I correct in?
That would be ours.
They done over 100,000
within the state. Yeah, that'd be our.
Because what's happening is for $25, I can buy a gun online, have it shipped to an FFL, Federal Firearms Dealer, and that gun may be $1,500, which would, at near a 10% tax, would be $150. So a lot of people are doing, I've had gun dealers, shops tell me that we're losing 100,000, just individual ones around Kansas, because of that somewhat loophole. So they would be covered and considered, they would be subject even though there's an individual, correct?
Yeah, I'm going to pull up bill language just to have it in front of me. Yeah, you have definitions, I think, in both bills. They're going to be not the same, but similar. You have marketplace sellers and you have marketplace facilitators. And it's for persons, the purpose of facilitator is somebody who's grouping people together to sell on their behalf versus the seller who.
Well, my point is I just want to make sure that we have a fair playing field, which I think we're all trying to create here. And, if maybe we need to look at definitions a little closer, because we do have a lot of people that are doing outside our state are doing a lot of sales, and it doesn't take $100,000 is a lot of money, but when you get in certain products, it don't take long to achieve $100,000. Thank you for that.
Representative Woodard.
Thank you, Mr. Chair. If it's appropriate, I'll leave Eric alone. But if it's appropriate, if not, I can do it later to follow up with the Department of Revenue. But since they'd be involved, I'd wonder if they could give a little bit of information about new Section 7, since they'll be the ones kind of, if I could hear from them on this, it would be helpful.
Let me see if there's any other further questions. I don't have anybody else on my list. Are there any further questions for Mr. Stafford? Seeing none, thank you for your testimony.
Thank you.
And now, Representative Woodard, would you like to address, Department of Revenue is still on, so.
Yes. If they can provide some clarity on new Section 7 for me, that would be helpful.
Sure. Thank you, Mr. Chairman and representatives. I don't know if there's, I think the language is pretty clear in addressing the any other taxes and fees that Mr. Stafford raised as a concern. If you look at the entire section, and I'm on page 5, line 23 and 24 of the bill, 2395, it says that also apply to any other taxes and fees as defined in this section, and that would be section 7. And the only taxes defined in this section are the sales, compensating, transient guest, and 911 fees. Nothing else. So the as defined under this section modifies also apply to any other taxes and fees. So concerns about the gallonage tax or tobacco products tax, that doesn't exist in this bill as it's written. I don't know if that clarified things or not.
Yeah, I just had some questions sparked from other questions, so that was helpful for me. Thank you so much. Thank you, Mr. Chair.
All right, committee, I show no more opponent testimony. Is there anyone else wishing to appear as an opponent on House Bill 2395? Seeing none, we will close the testimony. Is there anyone else wishing to speak on 2395? Seeing none, we will officially close the hearing. And committee, that concludes our business for today. Thank you for your time and patience.